to eviction proceedings, pardon me, 7 years or older, keeping it in line with about the amount of time it takes a mortgage or a bankruptcy to come off of a credit report. And this amendment is the result of negotiation between stakeholders, including Community Legal Services of Philadelphia and the Pennsylvania Association of Realtors. I'm happy to answer any questions, but I won't take up any more of your time with the dulcet tones of my own voice.
Thank you, Representative, and stay there in case there's any questions. Council, any additional explanation on House Bill 1769?
1769 in its current form has a couple of provisions that just require landlords to notify the court to mark judgment satisfied or provide the tenant with a way to do so if they meet the requirements, obviously. The current version provides for a private right of action and for some provisions under the Consumer Protection Law. As the representative said, there is an amendment A05641 to the bill.
Council, you're in order on Amendment A05641.
A05641 simplifies the bill greatly by providing a single standard for sealing the eviction records. As noted, it would be when they are 7 years old or more. It also removes the provision providing that a violation of the Act constitutes a Consumer Protection Law violation and provides for basically a cap on damages for any violation.
Thank you, Council. We'll need a motion to adopt A05641 by Representative Kincaid, seconded by Representative Williams. Are there any comments on the amendment? Chairman Kaufman, you are in order on the amendment.
I note that tenants can be evicted from property for various reasons, which not just non-payment isn't the only reason. It could include manufacturing controlled substances on the property, harassment or assault of other tenants, domestic violence, or intentional vandalism. Are those carved out in this bill or amendment, or are those excluded as well? Those reasons for eviction?
The bill as amended actually gives no regard to the cause for eviction and simply provides for that thing to fall off or be removed from the record after 7 years. I will note briefly that the concerns that you raise are very real, Chairman. I myself own property, but just want to thank you and clarify for that. Yep.
No.
On the
Chairman Kaufman on the amendment.
Okay. Thank you. I certainly appreciate the intent to alleviate issues in the rental market. I certainly recognize that. I guess my concern is that in attempting to alleviate it for one segment of a community, it may exacerbate it for others. If you're a landlord with multiple tenants, they may have to intentionally raise rent to alleviate the loss that they may realize for other bad tenants that they're not able to weed out. It could cause potential landlords to weigh other factors more heavily, such as credit scores, instead of looking at actual evictions, being able to use that as a part of their measure, causing others to be left out of the rental market because they're having to look at credit scores rather than actual actions of eviction. So, again, I appreciate the issue. I think we're seeing it all over Pennsylvania, not just Lancaster, not just big cities. We have issues in Chambersburg and Franklin County as well. I'm just not convinced that this is not a solution that's going to cause problems for others just as bad as who we're trying to solve it for currently. So with that, I'm going to be opposing the amendment and bill.
Any other comments or questions on the amendment? Secretary, please call the roll.
Chairman Briggs.
Yes.
Representatives Donahue.
Yes.
Hanbidge.
Designation, yes.
Hohenstein.
Yes.
Howard.
Designation, yes.
Kenyatta.
Designation, yes.
Kincaid. Mays.
Designation, yes.
Pielli.
Yes.
Rab.
Designation, yes.
Sanchez.
Designation, yes.
Schusterman.
Designation, yes.
Warren.
Yes.
Williams.
Yes.
Chairman Kaufman.
No.
Representatives Bonner.
Designation no.
Ecker.
Designation no.
Ham.
Designation no.
Clunk.
Designation no.
Ledbetter.
Designation no.
Allett.
Designation no.
Rigby. Rowe.
Designation no.
Schemmel.
Designation no.
Shalaba.
Designation no.
The amendment passes.
Thank you, Secretary. Amendment is adopted. We'll need a motion to report out House Bill 1769 as amended by Representative Pielli, seconded by Representative Hohenstein. Are there any comments on the bill as amended? Representative Kincaid on the bill.
Thank you, Mr. Chairman. As somebody who serves pretty regularly as both a landlord-tenant arbitrator and mediator, I see a lot of these issues that come up, and I want to make sure that we're clear about the impact of this bill. First of all, when it comes to criminal records and criminal activity, the rules around public housing require that landlords not consider any act and any conviction that is greater than 7 years old. So this is in line with federal law in that capacity, and mirrors state law in that capacity as well. The other thing is, when people are evicted, if they, not just if they owe money, but if they have caused damage to the property, that is part of the eviction process. So if there is a cost associated with repairing the damages to the property as a result of the eviction, that is all captured within the eviction case itself. So I do want to make sure that people do understand that this eviction ceiling does not mean that someone is not accountable for the actions that they have taken while at the property, that they're not accountable for what they did that resulted in the eviction. This merely means that, similar to criminal offenses, that landlords can't take into account evictions that are older than 7 years, and we are giving people just a little bit of distance to say, things fall off your credit report after 7 years. Criminal convictions are not considered in housing after 7 years. So evictions should be in that same category. And if you are evicted again, that will come up in the background. That will come up in the search. So if you are a problem tenant and you are consistently being evicted, even if an eviction that's 7 years or older falls off your record, newer evictions are going to show up. So this doesn't prohibit a landlord from being able to evaluate a tenant, whether or not it is, they are going to currently be an issue. But I don't believe that anyone in this room believes that we should hold somebody accountable for something that they did 7 years ago and have not done again. I believe that we should all support a second chance. So I appreciate this bill, and I do want to just make sure that we are clear about landlord-tenant law as it applies under this bill. Thank you, Mr. Chairman.
Thank you, Representative. Any other comments or questions before we go to roll call? I just want to thank Representative Smith-Waddell on your work on this. I know you spent the summer talking to a lot of advocates and stakeholders to get to this place. I know how close this is a priority of yours. Do you have any closing comments before we do a roll call?
I just want to thank the committee for its consideration.
Thank you very much. Secretary, please call the roll.
Chairman Briggs.
Yes.
Representatives Donahue. Hanbidge.
Designation, yes.
Hohenstein.
Yes.
Howard.
Designation, yes.
Kenyatta.
Designation, yes.
Kincaid. Mays.
Designation, yes.
Pielli. Rab.
Designation, yes.
Sanchez.
Designation, yes.
Schusterman.
Designation, yes.
Warren. Williams. Chairman Kaufman.
No.
Representatives Bonner.
Designation no.
Ecker.
Designation no.
Ham.
Designation no.
Clunk.
Designation no.
Ledbetter.
Designation no.
Allett.
Designation no.
Rigby. Rowe.
Designation no.
Schemmel.
Designation no.
Shalaba.
Designation no.
House Bill 1769 as amended passes.
Thank you, Secretary, and congratulations, Representative. House Bill 1769 passes and will be reported to the floor as amended.
Thank you all.
Last on today's agenda is House Bill 2018 by Representative Hanbidge. I'm having a hard time seeing if Representative Hanbidge is online. She can unmute and join us for some comments, followed by council for a brief explanation. I think I saw some activity. So, Representative Hanbidge, if you're interested, you have the floor.
Yes, thank you to the chairman for bringing this bill up. I have a cold. I'm not in Harrisburg sharing it with you right now, but I wish I were there because I think this is a really exciting bill. As we heard in our hearing in the spring, courts and judges and families are struggling with some of the lack of clarity and the repetitiveness that currently exists in our domestic relations regarding child custody. This bill is a way to streamline that, make it more cost effective for families, to try to move this process through the court system more quickly so that people can get resolution. And it creates more clarity around that issue while still including language that we came up with for Caden's Law. So I appreciate everyone's support.
Thank you, Representative. Council Claudius, any additional explanation?
No additional comments on the bill. I would note there is one amendment.
Council, you're in order on Amendment A05626.
This amendment essentially synchronizes the language with what was Senate Bill 55 and while retaining the emphasis on the best interest and primary consideration for safety of the child.
That was quick. We will need, thank you, Council. We will need a motion to adopt A05626 by Representative Hohenstein, seconded by Representative Donahue. Any comments on the amendment? Chairman Kaufman.
Thank you. I think the bill, as it originated, I didn't hear significant opposition to it. I think I understand. Am I right that the amendment is an attempt to fix the Caden's Law issue? Is that what the amendment is? Or maybe I should ask, what is the intent of the amendment? Maybe I'm way off.
Well, the bill and the amendment to some degree kind of streamline, I think was the word that Representative Hanbidge used, and that's what it is. It narrows down the factors. There's currently 16 factors. It narrows it down to 12 by incorporating some into others. The amendment retains most of that same language in the bill and goes a little bit further in terms of permitting frequent and continued contact as long as it's consistent with safety of the child. It explicitly provides those kind of things. And as you likely recall, the Senate Bill 55's passage changed some of the underlying language that's out there in the statute. So that it's an attempt to synchronize this with that.
Okay. On the amendment, please.
Chairman, you're in order on the amendment.
I appreciate that. I'm concerned if the amendment was brought rather last minute, and my concern is that one of, I think, our largest stakeholders in this issue, the Pennsylvania Bar Association, has not had the time to weigh in on the amendment, and I think is not supportive of. They support the bill, the intent of the underlying bill, but not the amendment. And I guess I would think it would be wise to go over the amendment, continue with the bill, and hopefully fine tune the amendment so we get it right the first time it's amended. Because I suspect it's just going to need another amendment to fix what could likely have been broken in the amendment process. And I mean, I know, that's not how it goes usually. So I'll be opposing the amendment in the bill if we continue on the process we're currently on.
Any other comments or questions on the amendment? So I mean, we had a hearing on this bill because of the passage of the Cadence Law. Tried to invite members to a lot of testifiers to participate in the process. And we circulated a draft of this amendment a few weeks ago. Got to some folks later than possible. I think the amendment is, other than just general vague concerns, I haven't heard any express concerns about the specific language. And there's always the opportunity to continue to have those conversations and do a floor amendment. So I'm voting yes on this. I'm bringing it up. I've offered it. I've expressed that to everyone. So if no one else has any comments, Secretary, please call the roll.
Chairman Briggs.
Yes.
Representatives Donahue. Yes. Hanbidge.
Designation yes online.
Hohenstein.
Yes.
Howard.
Designation yes.
Kenyatta.
Designation yes.
Kincaid. Yes. Mays.
Designation yes.
Pielli.
Yes.
Rab.
Designation yes.
Sanchez.
Designation yes.
Schusterman.
Designation yes.
Warren.
Yes.
Williams.
Yes.
Chairman Kaufman.
No.
Representatives Bonner.
Designation no.
Ecker.
Designation no.
Ham.
Designation no.
Clunk.
Designation no.
Ledbetter.
Designation no.
Allett.
Designation no.
Rigby.
No.
Rowe.
Designation no.
Schemmel.
Designation no.
Shalaba.
Designation no.
The amendment passes.
Thank you. The amendment is adopted. We'll need a motion to report out House Bill 2018 as amended by Representative Hohenstein, seconded by Briggs. Are there any comments on the bill as amended? Seeing none, if the Secretary could please call the roll.
Chairman Briggs.
Yes.
Representatives Donahue.
Yes.
Hanbidge.
Designation yes.
Hohenstein.
Yes.
Howard.
Designation yes.
Kenyatta.
Designation yes.
Kincaid. Yes. Mays.
Designation yes.
Pielli.
Yes.
Rab.
Designation yes.
Sanchez.
Designation yes.
Schusterman.
Designation yes.
Warren.
Yes.
Williams.
Yes.
Chairman Kaufman.
Designation, or no. Sorry, I was just going to get in my routine.
Representatives Bonner.
Designation no.
Ecker.
Designation no.
Ham.
Designation no.
Clunk.
Designation no.
Ledbetter.
Designation no.
Allett.
Designation no.
Rigby.
No.
Rowe.
Designation no.
Schemmel.
Designation no.
Shalaba.
Designation no.
House Bill 2018 as amended passes.
Thank you, Secretary. House Bill 2018 passes and will be reported to the floor as amended. We are at the end of the agenda, but I did want to flag, back in May, I had charged the Subcommittee on Family Law to have a hearing on House Bill 2303. That hearing being held by the subcommittee will be on Monday at 11 a.m., I believe in the Majority Caucus Room. Majority Caucus Room at 11 a.m., House Bill 2303, introduced by Representative Howard, will be discussed for the members. This meeting stands adjourned. Thank you.